The Supreme Court, in a 5-3 ruling, affirmed the district court's preliminary injunction as to 3 of these provisions. Justice Kennedy wrote for the majority and was joined by Chief Justice Roberts and Justices Ginsburg, Breyer, and Sotomayor. Justice Kagan was recused, while Justice Scalia dissented, joined by Justices Thomas and Alito. Justice Kennedy began by accepting the argument of the United States that immigration is solely in the control of the federal government. Anything done with regard to immigration has foreign policy implications and states cannot have their own foreign policy. The court quoted its 1942 ruling in Hines v. Davidowitz that states cannot contradict or complement federal immigration efforts and, any of the most important and delicate of all international relationships, has to do with the protection of the just rights of a country's own nationals when those nationals are in another country. 81. In fact, the court found that the Arizona requirement, 3, that non-citizens carry papers at all times showing that they are lawfully in the country was preempted based on Hines, which had held that alien registration was exclusively in the province of the federal government. The court found the criminal prohibition against those unlawfully in the country from seeking or receiving employment in Arizona, 5C, was preempted based on Congress's explicit choice to impose sanctions on employers and not employees. Justice Kennedy explained, the legislative background of the federal law underscores the fact that Congress made a deliberate choice not to impose criminal penalties on aliens who seek, or engage in, unauthorized employment. 82. The court found that 6, which allows police to arrest and detain without warrants where there is probable cause that a person is unlawfully in the United States, is preempted because it was solely in the discretion of the federal government to decide whether to detain a person for possible deportation. The court declared, by authorizing state officers to decide whether an alien should be detained for being removable, 6 violates the principle that the removal process is entrusted to the discretion of the federal government. A decision on removability requires a determination whether it is appropriate to allow a foreign national to continue living in the United States. Decisions of this nature touch on foreign relations and must be made with one voice. 83. Finally, the court reversed the preliminary injunction as to the provision that allows police to question individuals about their immigration status if they are stopped for other reasons and if there is reasonable suspicion that they are not lawfully in the United States. The court stressed that it was too uncertain as to how this would be implemented to allow it to decide constitutionality at this stage. The court explained, the nature and timing of this case counsel caution in evaluating the validity of 2b. The federal government has brought suit against a sovereign state to challenge the provision even before the law has gone into effect. There is a basic uncertainty about what the law means and how it will be enforced. At this stage, without the benefit of a definitive interpretation from the state courts, it would be inappropriate to assume 2b will be construed in a way that creates a conflict with federal law. 84. But this provision was substantially narrowed as the court said that police cannot extend the duration of a stop to check immigration status and also that state and local police cannot arrest individuals whom they determine to be illegally in the country. Moreover, the court left open the possibility of an as-applied challenge to this provision of SB 1070 if it could be shown that it was being applied in a racially discriminatory fashion. Justice Scalia wrote a vehement dissent as to those parts of the law that the majority had deemed preempted. His central thesis was that Arizona, as a sovereign state, had the authority to decide who could be within its borders. He wrote, as a sovereign, Arizona has the inherent power to exclude persons from its territory, subject only to those limitations expressed in the Constitution or constitutionally imposed by Congress. 85. The dissent accepted Arizona's central argument that SB 1070 supplemented federal immigration laws and did not conflict with them. Arizona v. United States is an important and powerful affirmation that states are significantly limited in their ability to regulate immigration. The question also arises as to how far the federal preemption of state laws affecting foreign policy extends. The issue arose in the 1950s in the context of whether states could prohibit advocacy of overthrow of the government. Initially, in Pennsylvania v. Nelson, in 1956, the court found that a Pennsylvania sedition statute was preempted by the Federal Smith Act, which prohibited the knowing advocacy of the overthrow of the United States government by force or violence. 86. The federal law contained no preemptive language. Congress did not express an intent to preempt state law, and there was no conflict between the Pennsylvania law and the Smith Act. Nonetheless, the court concluded that there was preemption. The court said that the scheme of federal regulation is so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it. 87. The court emphasized that the law touched foreign policy and thus concerned a field in which the federal interest is so dominant that the federal system must be assumed to preclude the enforcement of state laws on the same subject. 88. But 3 years later, in Upholz v. Wyman, the court held that Congress had not preempted all state sedition laws. 89. An individual was held in contempt for failing to comply with a subpoena that was issued by the New Hampshire Attorney General as part of an investigation into possible subversive activity in the state. The court found that states were allowed to prohibit subversive activity, and it narrowly construed Nelson as only prescribing a race between federal and state prosecutors to the courthouse door. 90. The comparison between Nelson and Upholz is revealing in terms of the problems with field preemption. The decision as to whether the Smith Act preempts similar and related state laws turns entirely on a judgment by the court as to whether it is a field that should be left entirely to the federal government. Although the court is influenced by statutory language and legislative intent, inevitably these are sufficiently ambiguous as to require a choice by the court. 2 later cases illustrate preemption in the area of foreign policy. In Crosby v. National Foreign Trade Council 91, the court considered a Massachusetts law that prohibited the state and its agencies from purchasing goods or services from companies that do business with Burma, Myanmar. The state adopted this law because of human rights violations in that nation. The Supreme Court unanimously found that the state law was preempted by federal law. Justice Souter, writing for the court, explained that Congress had enacted a sanctions law against Burma. He found that this preempted states from imposing their own sanctions. The decision, though unanimous, can be questioned because Congress had not expressed or implied any intent to preempt states from imposing sanctions and the state law was not inconsistent with the federal law. The state was simply choosing how it would spend its taxpayers' money and who it would do business with. Many state and local governments adopted similar laws refusing to contract with companies doing business in South Africa at the time of apartheid. On the other hand, the court's unanimous ruling can be seen as following the tradition of having federal laws occupy the field with regard to foreign policy. The court also found preemption because of potential foreign policy issues in American insurance. Arson v. Garamendi. 92. California's Holocaust Victim Insurance Relief Act required any insurer that did business in California and that sold insurance policies in Europe that were in effect during Holocaust era to disclose certain information about those policies to the California Insurance Commissioner or risk losing its license. The state was concerned that insurance companies were stonewalling and refusing to disclose information about their Holocaust era policies. The law applied only to insurance companies doing business in California and only required disclosure of information. Nonetheless, in a 5-4 decision with an unusual split among the justices, the court found the California law preempted based on the implied dormant foreign affairs power of the president. Justice Souter wrote the opinion for the court and the 4 dissenters were Justices Stevens, Scalia, Thomas, and Ginsburg. The majority acknowledged that neither the statute nor executive agreements contained a preemption clause and that there was no conflict between the California law and any federal law. Nonetheless, the court concluded that the California law limited the ability of the president to negotiate executive agreements in this area and thus was preempted. 93. Justice Souter's majority opinion stressed that resolving Holocaust-era insurance claims that may be held by residents of this country is a matter well within the executive's responsibility for foreign affairs. 94. The court concluded that the choice of the president to not aggressively pursue policies in the area precluded California from making a contrary choice. On the one hand, Garamendi, like Crosby, reflects the court according broad authority to the federal government in matters touching foreign policy and thus expansively defining field preemption. But the decision also is troubling in that it finds preemption where there is no express clause in any federal law or executive agreement precluding state regulation and where there is no conflict between the state law and anything the federal government had done. From a federalism perspective, such a broad view of field preemption dramatically limits the choices state governments may make. Federal regulations as field preemption. The same issue arises in other areas, besides foreign policy and immigration, where there is extensive federal regulation and a claim that the field excludes state and local actions. Perhaps the most frequently cited case concerning field preemption is Rice v. Santa Fe Elevator Corporation. 95. The issue in Rice was whether states could regulate grain elevators licensed by the federal government. The court concluded that such regulation was preempted even though Congress did not expressly preclude state regulation. The court saw the purpose of the federal law as eliminating dual state and federal regulation of grain warehouses and found preemption based on Congress's desire to make preemption exclusive in the field. But the dissent argued, as the dissent has contended in many cases finding preemption, that Congress had the power to preempt state laws, if it wanted to do so, and that preemption should not be found absent such statutory provisions. 96. Another prominent example of the Supreme Court finding field preemption based on extensive federal regulation is City of Burbank v. Lockheed Air Terminal, Inc. 97. The issue was whether a city ordinance prohibiting jet flights at a local airport between 11 p.m. and 7 a.m. was preempted by the Federal Aviation Act and the Noise Control Act amendments to it. 98. Although there was no provision in either law expressly preempting state regulation, the court declared, it is the pervasive nature of the scheme of federal regulation of aircraft noise that leads us to conclude that there is preemption. 99. The court exhaustively reviewed the legislative history of the federal laws and expressed concern that allowing such local regulations would impede the ability of federal regulators to control air traffic flow. 100. The court concluded, control of noise is of course deep-seated in the police power of the states. Yet the pervasive control vested in EPA and in FAA under the 1972 Act seems to us to leave no room for local curfews or other local controls. 101. Yet the court has refused to find preemption in other areas where there is extensive federal regulation. For instance, in Hillsborough County, Flo. v. Automated Medical Laboratories, Inc., the court concluded that federal regulations governing the collection of blood plasma from paid donors did not preempt local ordinances. 102. A city adopted rules requiring that all paid blood donors be tested for hepatitis and be given a blood alcohol test. The Food and Drug Administration, pursuant to federal law, had adopted many regulations of such paid donations. The blood bank argued that the comprehensive federal regulation preempted the local ordinance. The Supreme Court disagreed and emphasized the absence of any intent by Congress to preempt the entire field. The court stressed that the regulation of health and safety matters is primarily, and historically, a matter of local concern. 103. The court also said that the judiciary should be more reluctant to find preemption of a field based on regulations as opposed to statutes. The court said, we are even more reluctant to infer preemption from the comprehensiveness of regulations than from the comprehensiveness of statutes. As a result of their specialized functions, agencies normally deal with problems in far more detail than does Congress. To infer preemption whenever an agency deals with a problem comprehensively is virtually tantamount to saying that whenever a federal agency decides to step into a field, its regulations will be exclusive. Such a rule, of course, would be inconsistent with the federal-state balance embodied in our Supremacy Clause jurisprudence. 104. In other areas, too, the court has refused to find field preemption even though there is extensive federal regulation. For instance, in Goldstein v. California, the court refused to find that a state law prohibiting record piracy was preempted by federal copyright laws. 105. Even though copyright traditionally has been regulated exclusively by the federal government, the court refused to find preemption because of the absence of any expression by Congress of a desire to prevent such state regulation. Similarly, in New York State Department of Social Services v. Dublino, the court found that federal law did not preempt a state law that required that welfare recipients participate in an employment program. 106. The court acknowledged the extensive federal regulations, but found no indication that Congress meant to preclude state regulation in the area. Making sense of field preemption. As the above cases indicate, there is no clear rule as to when courts will find field preemption. However, several criteria can be identified that are crucial in determining whether there is field preemption. First, is it an area where the federal government traditionally has played a unique role? For example, the Supreme Court has found field preemption with regard to foreign policy and immigration based on the federal government's preeminent and exclusive role in these areas. Second, has Congress expressed an intent in the text of the law or in the legislative history to have federal law be exclusive in the area? For instance, in Rice, described above, the court found that the purpose behind the federal law was to eliminate dual federal and state regulations of grain elevators. Third, would allowing state and local regulations in the area risk interfering with comprehensive federal regulatory efforts? Field preemption can be found in the absence of such interference, but the potential for impeding the federal scheme can be crucial in a court finding preemption. In the Burbank case described above, a key factor in the court finding preemption was its fear that a multiplicity of city curfew ordinances for airports would undermine the ability of the Federal Aviation Administration to regulate airspace in a safe and efficient manner. Fourth, is there an important traditional state or local interest served by the law? Although the court often has found preemption even when the state or local law serves an important and traditional purpose, such as noise control in Burbank, in other cases the court has emphasized the significance of the state interest in avoiding preemption. For instance, in Mora v. Hamilton, the court upheld a state law preventing the carrying of cars over the cabs of auto transport trucks, even though there was extensive regulation by the Interstate Commerce Commission, because of the traditional and important state interest in regulating highway safety. 107 At the very least, the court is more likely to avoid finding field preemption if it regards the state interest as particularly important and in an area that has been traditionally regulated by state and local governments. These factors, of course, are not mutually exclusive, and the presence of more than one favoring exclusive federal control greatly enhances the likelihood that preemption will be found. But it must be recognized that the court usually has great discretion in deciding whether a particular area has been left exclusively to federal law and, if so, how far the preemption extends. Although the court often says that it looks to congressional intent to decide if there is field preemption, 108 rarely is the intent clear. The court is thus left to decide whether a field is preempted and, if so, the scope of that preemption. 5.2.4 Conflicts between state and federal laws. Preemption if impossible to comply with federal and state law. If federal law and state law are mutually exclusive, so that a person could not simultaneously comply with both, the state law is deemed preempted. The Supreme Court has explained that such preemption exists when compliance with both federal and state regulation is a physical impossibility. 109. McDermott v. Wisconsin is illustrative. 110 Federal law required labeling of maple syrup in a manner that Wisconsin law prohibited. A company could not simultaneously comply with both federal and state law, so the state law was deemed preempted. Similarly, in Hisquiadu v. Hisquiadu, the court found that a federal law prohibiting attachment of railroad retirement income preempted a state community property law that would have expressly divided railroad retirement income in the case of divorce. 111. Problems in deciding if there is a conflict. The difficulty with regard to this type of preemption is in deciding whether there is a conflict between federal and state law. The fact that federal law and state law are different does not necessarily mean that there is an impermissible conflict. Rather, it could be that the federal government has set a minimum standard and permits states to set stricter standards. However, it also may be that the federal regulation was meant to be the standard, and the differing state standard is thus preempted. An example of this difficulty is Florida lime and avocado growers, Inc. v. Paul. 112 The Department of Agriculture adopted regulations for measuring the maturity of avocados. California adopted a stricter rule, which prohibited the transportation or sale of avocados that had less than 8% oil. The result was that some Florida avocados, which were permissible under the federal regulation, were prohibited under the California law. The issue before the Supreme Court was whether there was mutual exclusivity between the federal and state regulations. The federal and state laws are mutually exclusive if the federal regulation is seen as setting the exclusive standard for avocados. However, the federal and state law are not mutually exclusive if the federal regulation is viewed as setting only the minimum standard for saleable avocados, with states allowed to set stricter standards. Nothing in the federal law or regulation answered this question. The court concluded the latter, that the federal regulation was the floor, but not the ceiling. It was the minimum standard, but states were allowed to set stricter regulations if they wished. In part, the court emphasized the traditional role of states in regulating the marketing of food products. 113 The court also relied in part on the history of the adoption of the federal regulation. The court observed that the federal regulation was motivated less by a desire to ensure palatable avocados than by successful lobbying efforts of Florida avocado growers. The court remarked that the pattern which emerges is one of maturity regulations drafted and administered locally by the growers' own representatives, and designed to do no more than promote orderly competition among the South Florida growers. 114. Numerous other cases reflect the same problem. When states set stricter standards in an area than does federal law, it is necessary to decide whether the federal government meant its law to be exclusive or only intended to set a minimum standard that states may exceed. Unfortunately, almost never does the statute or regulation answer this question, and rarely is there any legislative history on point. Thus, mutual exclusivity preemption, like the other areas of preemption, involves the court making a judgment about what Congress or a federal agency intended when they said nothing about their intent. This issue often arises in the context of state environmental laws. For instance, in Mid-Atlantic National Bank v. New Jersey Department of Environmental Protection, there was a seemingly direct conflict between a state's environmental law and a federal bankruptcy statute. 115 New Jersey law prohibited the abandonment of property of the estate on which toxic wastes had been dumped unless the site had been completely decontaminated. The federal bankruptcy law expressly allowed the trustee in bankruptcy to abandon any property that is burdensome to the estate or that is of inconsequential value to the estate. 116 These provisions appear to be mutually exclusive. Federal law allowed abandonment of the property, while state law prohibited it. The court, however, found that there was not preemption of the state law. The court reviewed the Bankruptcy Code's legislative history and concluded that Congress did not intend for the Bankruptcy Code to preempt all state laws that otherwise constrain the exercise of a trustee's power. 117 Also, the court looked to federal environmental laws and said that they evidence a congressional goal of protecting the environment against toxic pollution. 118 In other words, even in the face of a clear conflict between federal and state law and apparent manifest mutual exclusivity, the court used its view of Congress's overall intent to reject a preemption claim. Another illustration in the environmental area is Wisconsin Public Intervenor v. Mortier. 119 The issue was whether the Federal Insecticide, Fungicide, and Rodenticide Act preempted local governmental regulation of pesticide use. The court found that the stricter local rules were permissible because the federal law set the minimum standard and did not preempt the entire field. Subsequently, the court considered conflict preemption in the product liability area, in Geyer v. American Honda Motor Company, Inc. 120 Alexis Geyer bought a 1987 model Honda Accord. She was seriously injured when the car crashed into a tree. She sued saying that the absence of airbags was a design defect that was responsible for her injuries. The Department of Transportation had promulgated rules pursuant to the National Traffic and Motor Vehicle Safety Act for 1987 automobiles. The regulations required that cars have passive restraint systems and gave manufacturers three choices. One was airbags, another was lap and shoulder belts, which were in Geyer's car. The defendant argued that Geyer's suit was preempted by federal law because it built the car in compliance with the federal safety requirements. The problem with this is that the National Traffic and Motor Vehicle Safety Act, which was the basis for the Department of Transportation regulations, had a savings clause that nothing within the law was meant to preempt any other cause of action that might exist. 121 Geyer argued that this provision prevented a finding of federal preemption. The Supreme Court rejected Geyer's argument and found federal preemption notwithstanding the savings clause. Justice Breyer, writing for the majority, said that this was not a situation of express preemption, but instead conflicts preemption. 122 Allowing state liability for cars made in compliance with the federal safety standard was deemed to conflict with the federal law. Justice Breyer said that the savings clause did not foreclose preemption because there is no indication that Congress wanted to permit lawsuits when cars were made in compliance with the Department of Transportation's safety regulations. 123 Geyer is important because it provides a basis for defendants to claim preemption to tort liability when products are made in compliance with a federal safety standard. The case also is significant in showing the need for judicial interpretation of savings clauses 124 and, more generally, judicial determination of whether there really is a conflict between federal and state law. Making sense of conflict preemption. As in all areas of preemption law, there are potentially cases where it is easy to identify conflict preemption. For instance, if the federal government requires conduct that the state prohibits, conflict preemption will be found. As indicated above, however, there also are many harder cases that depend on determining federal intent in order to decide whether the federal law and the state law are mutually exclusive. As is the case throughout preemption law, this intent is rarely expressed or clear, and courts thus must make a judgment about how best to effectuate the policy behind a particular federal law. 5.2.5 State laws that impede achievement of federal objectives. Even if Congress has not expressly preempted state law, and even if federal law does not occupy the field and there is no conflict between the federal and state laws, preemption still can be found if a court concludes that the state law interferes with a federal goal. The court has explained that state law will be deemed preempted if it stands as an obstacle to the accomplishment and execution of the full purposes or objectives of Congress 125. For example, in Nash v. Florida Industrial Commission, the court found preemption of a state law that denied unemployment benefits to those who filed an unfair labor practice charge with the National Labor Relations Board. 126 The court saw encouraging the filing of such charges to be a key purpose of the National Labor Relations Act, and therefore a state law that imposed a punishment for doing so was deemed preempted. Similarly, in Perez v. Campbell, the court concluded that federal bankruptcy law preempted a state law that suspended the driver's licenses of those who did not pay judgments arising from automobile accidents, even if the debt had been discharged in bankruptcy. 127 The court said that the purpose of the federal bankruptcy law was to provide uniform standards for determining when a debt was discharged, and that to allow states to regulate would undermine this purpose. In some very important recent cases, the Supreme Court has considered preemption in the context of liability of prescription drugs. The court has held that makers of brand name drugs may be sued for failure to adequately warn consumers, even when the warning labels had been approved by the Food and Drug Administration. But it also has held that suits against makers of generic drugs are preempted, both for failure to warn claims and design defect claims. In Wyeth v. Levine, the court considered whether the Food and Drug Administration's approval of warning labels on a prescription drug preempted state tort liability on a failure to warn theory. 128 The court ruled against preemption, finding that allowing tort liability would further the federal regulatory goal, informing doctors and patients of the dangers of prescription drugs. The drug company argued both that there was conflicts preemption and that allowing tort liability would undermine the federal objective of having an expert agency decide the content of warnings. The court rejected both of these arguments, concluding that nothing in federal law precludes drug companies from providing more information and that allowing tort liability would further the federal objectives. Justice Stevens concluded the majority opinion by declaring, in short, Wyeth has not persuaded us that failure to warn claims like Levine's obstruct the federal regulation of drug labeling. Congress has repeatedly declined to preempt state law, and the FDA's recently adopted position that state tort suits interfere with its statutory mandate is entitled to no weight. Although we recognize that some state law claims might well frustrate the achievement of congressional objectives, this is not such a case. 129. But 2 years later, in Pliver v. Mensing, the court ruled that makers of generic drugs cannot be sued on a failure to warn theory. 130 The case involved a drug sometimes prescribed for those with diabetes to speed digestion. It is now known that in about 30% of cases prolonged users will suffer horrible irreversible neurological side effects. But the court, in a 5-4 decision with Justice Thomas writing for the majority, concluded that suits against generic drug companies on a failure to warn theory are preempted by federal law. Justice Thomas, joined by Chief Justice Roberts and Justices Scalia, Kennedy, and Alito, reasoned that the Food and Drug Act allows a generic drug to be sold so long as it is chemically the same as the brand name drug and so long as it has the warning label approved for the brand name drug. The court said that because the generic drug had to have the warning label approved for the brand name drug and could not change it, a suit on a failure to warn theory was preempted by federal law. 131. Justice Thomas acknowledged the incongruity that after Wyeth the makers of brand name drugs can be sued for a failure to warn, but not the makers of generic drugs. This was the key point of the dissenting opinion written by Justice Sotomayor, and joined by Justices Ginsburg, Breyer, and Kagan. It made no sense to allow a suit against the maker of a brand name drug and bar a suit against the maker of a generic drug that is the identical chemical compound. But Justice Thomas, writing for the court, acknowledged this and said it was because of how Congress wrote the statutes. Had Mensing and DiMahi taken Reglan, the brand name drug prescribed by their doctors, Wyeth would control and their lawsuits would not be preempted. But because pharmacists, acting in full accord with state law, substituted generic metoclopramide instead, federal law preempts these lawsuits. We acknowledge the unfortunate hand that federal drug regulation has dealt Mensing, DiMahi, and others similarly situated. But it is not this court's task to decide whether the statutory scheme established by Congress is unusual or even bizarre. 132. The court followed this decision in Mutual Pharmaceuticals v. Bartlett, which extended Pliva v. Menzing and found that design defect suits against generic drug makers are also preempted by federal law. 133 Karen Bartlett took a generic form of the prescription pain reliever, Sulindac. She then experienced a horrific side effect, called toxic epidermal necrolysis. 60 to 65% of the surface of her skin deteriorated, was burned off, or turned into an open wound. She spent months in a medically induced coma, underwent 12 eye surgeries, and was tube-fed for a year. She is now severely disfigured, has a number of physical disabilities, and is nearly blind. The Supreme Court held that her claim for a design defect was preempted by federal law. Justice Alito wrote for the court in a 5-4 decision. The court concluded, in the instant case, it was impossible for Mutual to comply with both its state law duty to strengthen the warnings on Sulindac's label and its federal law duty not to alter Sulindac's label. Accordingly, the state law is preempted. 134. The court explained that New Hampshire law requires that manufacturers not sell drugs, or other products, that are unreasonably dangerous. The court said that in the context of prescription drugs it would be necessary to redesign a drug to increase its usefulness or reduce its risk of danger. But the maker of a generic drug cannot redesign it. Federal law requires that for it to be sold it must be identical to the brand name version. Therefore, Justice Alito reasoned that the only way for a generic drug company to reduce the risk would be to strengthen the warning for consumer. Pliva v. Menzing, though, held that generic drug companies cannot change the warning label, but instead must include exactly the same warning label approved for the brand name drug. The result is that makers of generic drugs cannot be sued on a design defect theory or a failure to warn theory. Justices Breyer and Sotomayor each wrote dissenting opinions and disputed the majority's contention that it is impossible to comply with both federal and state law. They said that there was a way for the drug company to do this: cease selling the product in the state or decide to pay the penalty for doing so. Problem with deciding if state law impedes a federal objective. The difficulty in applying this type of preemption is often in determining the federal objective and whether a particular type of state law is inconsistent with it. A comparison of two cases, Pacific Gas and Electric v. State Energy Resources Conservation and Development Commission 135 and Gade v. National Solid Wastes Management Association 136, powerfully illustrates this problem. Pacific Gas and Electric involved a California law that imposed a moratorium on the construction of nuclear power plants until the State Energy Commission determined that there was a safe means of disposing of high-level nuclear wastes that had been approved by a federal agency. The utility argued that this law was preempted by the federal government both because Congress intended to preempt the field of nuclear regulation and because the state law interfered with the federal objective of encouraging the development of nuclear power. Although these are two distinct types of implied preemption, both turn on congressional intent. The Supreme Court rejected both preemption arguments and upheld the state law by concluding that Congress's intent was to ensure safety, while the state's goal was economic. As to the field preemption argument, the court said Congress intended that the federal government have exclusive authority to regulate safety, but that the states retain their traditional responsibility in the field of regulating electrical utilities for determining questions of need, reliability, cost, and other related state concerns. 137 The court concluded that the California law was not preempted because its main purpose was economics and not safety. The court noted that California has maintained, and the Court of Appeals agreed, that the law was aimed at economic problems, not radiation hazards. Without a permanent means of disposal, the nuclear waste problem could become critical, leading to unpredictably high costs to contain the problem or, worse, shutdowns in reactors. 138 The court said that because it accepts California's avowed economic purpose, the statute lies outside the occupied field of nuclear safety regulation. 139. The utility also argued that the state law was preempted because it impeded the federal goal of encouraging the development of nuclear reactors as a source of electrical power. The court acknowledged that, here is little doubt that a primary purpose of the Atomic Energy Act was, and continues to be, the promotion of nuclear power. 140 Yet the court rejected the preemption argument by characterizing Congress's purpose as encouraging nuclear power only to the extent that it was economically feasible. Justice White, writing for the court, said that Congress has left sufficient authority in the states to allow the development of nuclear power to be slowed or even stopped for economic reasons 141. Thus, in determining whether the California law interfered with achieving the federal objective, the court had to make two major choices. One was in characterizing the federal objective, the other was in characterizing the state law and its purpose. If the court saw a broad purpose for the Atomic Energy Act in encouraging the development of nuclear power, then the state law, which obviously limited it, would be preempted. The court avoided preemption by more narrowly characterizing the federal goal as promoting nuclear reactors only when they were economically feasible. Additionally, if the court characterized California's purpose as ensuring safety before construction of nuclear power, then the law would have been preempted. The court avoided preemption by accepting California's claim that its goal was economics, even though the law was written in terms of preventing construction of nuclear plants unless the safety of disposal was ensured.